Yes, sir. Good morning.
Morning. May it please the court, my name is Robert Sinsheimer. I represent Edwin Mejia.
How do you pronounce his name?
Mejia, I believe. It may actually be Mejia, frankly.
That's what I thought, but I don't know.
The case was a relatively average circumstantial case. It was not a weak case necessarily, although I call it that at one point in the brief. But neither was it a really strong case. Because, I'm talking about from the government's perspective. Because the meat of the case from the government's perspective was a cooperating witness. And this court has said repeatedly, over and over again, that almost by definition, cooperating witnesses are to be viewed with an element of substantial skepticism.
But you did have two others who had nothing, you had two others who had nothing to do with this whatsoever, right?
Well,
Mr.
you had
Rosa?
people to put them at the scene, if that's what you're referring to.
That is what I'm referring to.
And you had the sister,
Yeah.
who
Well,
really had no axe to grind, but neither did she know anything other than that she'd gotten this note.
Well-
And the note
Well, hadn't she been asked to drive the car?
to a robbery, but nothing more specific than that. I mean, the note was, help us out, we'll pay you some money.
it's on the same date.
Correct. But, as I say, it's a solid circumstantial case. It's not the kind of case that we're seeing these days with DNA or other kind of extremely strong circumstantial evidence. It certainly wasn't in any way guilt to a mathematical certainty.
Yeah, but it tells a better story sometimes. I mean, there's nothing wrong with circumstantial evidence.
I didn't say there was anything wrong with it, and I understand that sometimes by allowing the jury to draw their own conclusions, there's a power in that. However you rank it on a continuum, it's a case that's certainly not mathematically airtight, and that leads to the first error that I want to discuss. Second in the brief, but first I think for the purposes of oral argument, which is the error that the court committed in simply tacking on language to the Webster charge that had no business being there. As far as I know, it had never been there before, and mixed apples and oranges in a very substantial way, because we have a good, solid Webster charge in this case. And then the court says it's not necessary for the Commonwealth to prove that no one other than the defendant could have performed or participated in the acts alleged in this case. And that's just...
Wasn't the story that there was somebody else in the car?
There was a statement from the defendant allegedly to the cooperating witness that there was someone else at the robbery, that it split up the money. But he wasn't charged as a joint venturer.
I guess my point is you don't need to be charged as a joint venture, and this wasn't a joint venture
Especially
charge.
not after Zanetti, which came down, I think, in 2009. But that's exactly the point, Your Honor. Had they gotten a good, solid Zanetti kind of charge, then, in other words, if the government was concerned enough about that statement, which frankly I don't think it had to be, but if it was, and they asked for the kind of charge that this court has sanctioned, I wouldn't be here arguing the kind of error that comes up from this 1980 case that's utterly irrelevant to this set of facts. Because Casale, or Casale, however you say it, was a case involving lots of alleged co-defendants. I think there were 3 in the Casale case. And it did create the kind of problems that necessitated this instruction in the joint venture context. But what I'm suggesting here, and I'm suggesting you look at this really closely, is that really this had the capacity to confuse the jury and to denigrate the concept of reasonable doubt. And here's why in plain English. If you accept the basic notion that, in fact, the government must prove its case, it had to prove that this was the guy that did it. Never mind the burden, the level of proof. We all know it's not to a mathematical certainty, but that's already addressed in Webster, clearly. So you have the Webster charge, and then the judge goes on to say, and they don't really have to prove that this was the guy who did it.
No.
Oh, that's not what it's saying.
Well, I'm paraphrasing. I mean, I've given you the precise
A
language, of
certain
course.
poetic license.
Well, no, what I'm really trying to do is explain how it could have been horribly confusing. I understand that the language, the precise sentence, it is not necessary for the Commonwealth to prove that no one other than the defendant could have performed or participated in the acts alleged. But respectfully, it was necessary to prove that. They had to prove that this was the guy who did it. Then they go on to say that another person might have had an opportunity only goes to the weight of the evidence. The simple fact of the matter is this. If, capital IF, if there was enough doubt about the question of whether my client was the one who committed, or was there, committed this crime, then he was entitled to an acquittal. Period. Now, I've heard the question suggesting that the court probably thought it was a stronger case than I am arguing, and I understand. I guess the good news there is the court's read the brief and knows the facts. The simple fact of the matter, though, is everybody's innocent until proven guilty. They have to prove that he did it, and this language cuts against that.
So if you, does it, one way to look at what you're saying is, or let me ask you this, if the judge had said what he said, and then had added a sentence to the effect of, doesn't matter that you don't have to prove somebody else didn't participate, but you do have to find this is the guy, beyond a reasonable doubt that this is the guy who did it, you wouldn't have an argument. Is it the lack of the last repetition?
No, it's not so much repetition, but it is consistent with what I argued to you earlier, is if they wanted a joint venture and they asked for it, they could have got something consistent with Zanetti, I wouldn't have the argument I'm having now. My argument is that it confuses the Webster charge. It undercuts it. And especially where it is in the order of events. It's clearly intended as part of the Webster charge. And I know that the court was either amused or discomfited by my paraphrase, which was a little aggressive maybe, but I still understand, I still argue with sincerity that it takes away from the import of Webster. I cited a case in my brief, the federal habeas corpus case, Lanigan versus Maloney. And the reason for citing that case is to respectfully remind this court that this is a matter of constitutional dimension. And what they say in Lanigan, I know you don't usually like lengthy quotes, but there's a good solid chunk of Lanigan replicated in the brief. What it basically says is, look, the government doesn't have to prove beyond a reasonable doubt to a mathematical certainty, but again, if you'll forgive the plain English, it's darn close. It's not, a little more likely. It's not anything other than very close to mathematical certainty. And that's what Lanigan says as a matter of federal constitutional dogma, and I think that's consistent with all your cases. But what this does is it takes away from that. It says we have the standard Webster charge, but by the way, don't worry too much if he's not the right guy. And again, I understand that's a paraphrase, but I suggest respectfully, it's totally unnecessary. It's totally prolix. It's never, ever been part of Webster, and it does undercut Webster. So that's the essence of the argument, and unless there's further questions on that, I'd like to move on to the closing argument discussion. Before I get there, indulge me for a moment, if I could switch hats and just put on my officer of the court hat before I segue back into advocacy. I've argued before this court. I've had the privilege to argue 31 years on both sides of the fence. And for the life of me, I don't know why we use the phrase, quote, prosecutorial misconduct, unquote. When a trial judge, and I think all of the members of this court had been a trial judge at one point or another, I could be mistaken, but commits an error, we don't say they committed misconduct. We say they erred. It comes with the turf. If you're a hardworking, diligent trial judge, from time to time, I think, maybe there's someone with 100% batting average, I don't know, but from time to time, one is going to commit error and one is going to be reversed. No matter how diligent, no matter how capable, no, we don't suggest judicial misconduct in those circumstances. And now switching back to the advocacy aspect of my argument, I don't think we need to prove misconduct, and I wouldn't allege that in a million years, that my friend, Mr. Pappas, who I see sitting here, committed prosecutorial misconduct. What I suggest is that we have a hardworking prosecutor doing his best, just like we might have a hardworking trial judge doing his or her best. It committed reversible prosecutorial error. And that's the phrase I think we should see in, if you excuse me, my voice is a little dry. Thank you. And I think that's the reality of the situation. And before I get to what the errors are, I want to point out how carefully they were preserved by Mr. Doolan, who was the trial counsel, for two reasons. Number one, sometimes, unfortunately, these errors are not preserved, and in this case, there's no contest to that, so that's easy. Number two, if you look at the whole trial, the 13 volumes from start to finish, and I think one of the remarkable aspects of the case was the lack of objections, which tells me, and I suggest it would tell all the members of this court, that you have a very professionally tried case. The real issues are have been fought out in limine before the jury gets brought into the room. There's maybe an occasional objection to the form of the question so that the jury could see the lawyers are not asleep, but the issues really are never contested evidentially till we get to the closing argument, where when it's over, Mr. Doolan gets up and goes on for about 10 pages. And it's very clear, not just from the record in terms of preserving appellate error, but it's very clear that the tone suggests that the client was genuinely aggrieved. That after a very professionally and well-tried case, the government committed error, as I put it in its closing. Now, let's look at some of the specifics, and I laid them out with some specificity in the brief. One of the things that is stated is that the defendant was a liar. Now, there's...
I don't recall him using the word liar. He said he lied. Are you saying, and your brief does not use, your brief
I may have paraphrased it. That distinction, Your Honor, to me it's a distinction with that. Well, no, it's not quite.
It's not without a difference. One is a characterization of a person. The other is a description of a particular statement.
I agree with Your Honor, and I don't think he used the word liar, but I wasn't meaning to switch. It was just a little...
But is it wrong for a prosecutor to say that a defendant lied? It's
wrong to say it about post-arrest type statements. In that case, it's the Waite case, W-A-I-T-E, which I cited in my brief.
You mean if it...
Post-arrest denials, excuse me.
But this is with respect to specific statements that he says, I was at a Stop and Shop, and he says, that's not true. We know from records from the Stop and Shop that in fact is false. What's wrong with that?
You know, in isolation, first of all, he didn't say it that way. He said it's a lie. Okay. And I think that the cases suggest that that's language that really ought not be used.
Yes, but it's not, I think Justice Gantz, one part of what he's saying is that whatever phrase, it's about a statement of where he was. It's not a denial of this crime. These are specific facts. I mean, two things are true. One, it's not a denial of the crime, and the second is that these are instances where I think the prosecutor is saying what he said was a lie or was playing with the truth, or however he puts it, differs. But there was evidence that it wasn't true. I mean, it wasn't
There's
just
some
a
evidence.
characterization.
There was some evidence that was inconsistent with what the defendant is alleged to have said.
What do you say the prosecutor permissibly could have said?
I think it's best, particularly when someone doesn't take the stand, to talk about testimony that's accurate and not accurate. I think it's best to say, based on X, Y, or Z, I suggest to you, ladies and gentlemen, that this statement, if it was made, is not an accurate statement. I think once you cross the line to calling, well, be careful now, to using the word lie, you are suggesting that the person is a liar. And the number of times that the word lie was used, it wasn't used just once, it was used over and over again, was akin to calling him a liar. And I clearly think that was the intent.
But why is it wrong for a prosecutor to say, when he was describing his events that day, he lied, and he was lying for a reason? He was lying for a reason because if he were to have told, because the truth would mean that he would be where he wasn't supposed to be.
If it was just that simple and just that once, it might not be as erroneous as it is here, where it comes out so many times, and where they introduce the post-arrest statement, that the overriding inference is the government suggesting that he is a liar. And I think, again, you know, we always say we have to look at the closing arguments in their totality. But, you know, that works for both sides. It's impossible to say, okay, look at the whole closing argument and we win. You got to break it down. You got to look at clauses. That's the only way to have this kind of discussion at this level. And so the suggestion is that there really were comments on his credibility and implied suggestions about his failure to take the stand that I suggest were erroneous. Again, I don't suggest.
I'm sorry. What suggestions were made as to his failure to take the stand? That's the first time I've heard that.
Because once you start talking about distortions of the truth, and you put in the post-arrest statement, and the guy's just sitting there, it's bordering on that. The next suggestion. And again, because there are so many things, not any one statement that I'm picking on that I suggest is the problem. And going back to what Mr. Doolin suggested in the 10 pages at the end of the trial, that he felt there in the real cauldron. And another thing that bothered Mr. Doolin that he preserved was the excess inflammation. The circular reasons, you know, talking about this woman who clearly was led an exemplary life and was loved by her family, and she's none of these things anymore because of what he did to her. That adds nothing to persuasion. You might as well have said, you know, that's what happened. That doesn't do anything to help the jury decide if, in fact, it was him, which is the only question before the jury. It's vouching and it's inflammation and circular reasoning, which you have barred in Barrows. The other thing along the vouching argument, you know, is the body says what she can't say. And I understand that you can look at that as just a cute spin of a phrase, a description of the forensic evidence. But there's also an implication. You know, I know what she would have said if she was allowed to speak, or forgive me, if she was alive. He emphasized repeatedly the gruesome nature of the crime. I'm not going to beat that to death because it was a pretty gruesome crime. But in the totality, where we have these other errors, query whether that adds to the error. And then finally, and I see the time coming down, I do want to emphasize the closing flourish. In every man's life, in every person's life, there comes a time to be held accountable, and for Edward Mejia, that time is now. Now, that adds absolutely nothing to the question they have to decide, which is in fact it Edward Mejia who did it? The only question ever, from start to finish in this long trial, was, do they have the right guy? And for the government to stand up and say, that time is now, he's accountable, at the very end of all these other issues in the case, The last sentence out of a very able prosecutor's mouth, who clearly carries with him an indicia of knowledge and authority representing the people. Now is the time for he to be held accountable. Might as well say, I tell you, we got the right guy. So combined, again, I go back to my officer of the court hat. I call it reversible prosecutorial error. Nothing more than a hardworking prosecutor who committed error the way a trial judge could have in any case that gets reversed. But I suggest that it is reversible, and I suggest that you reverse the conviction. Unless you have questions, thank you very much.
Good morning, Chief Justice and Justices of the Court. May I please the Court? My name is Macy Lee. I represent the Commonwealth in this appeal, and with me at counsel table is John Pappas, who was the trial prosecutor. I assert to the Court there is absolutely no prejudicial error to any portions of the prosecutor's closing argument. If the Court desires, I can dissect the argument in piecemeal.
Well, I'm interested when you use the phrase prejudicial error. Was there an error that you think wasn't prejudicial or no error at all?
I'm going to assume that there's no error, but if there were any possibility of an error, it was not prejudicial given the curative instructions that the trial judge provided at the end of the closing arguments.
I also see you didn't specifically address the he lied argument or the case that supported the argument in the defendant's brief.
I did not, mainly because I was allowed only 50 pages for this brief, but I will certainly address it today. And there was absolutely no error in the trial prosecutor's statement that what the defendant said was not truthful, and that we all know that it's a lie. The evidence in this case was very overwhelming. It is very clear that the defendant's statement, and was his pre-arrest statement, and it was a statement that took place at his apartment in Everett, that he had left his apartment at 9 a.m. to go shopping in downtown Boston. That is absolutely untrue given the overwhelming evidence. There were photographs, there were phone records that indicated that the defendant made a telephone call at an MBTA train station to Vanessa Pineda at the home at approximately 11 o'clock in the morning. There's also photographs of him at the Stop and Shop, and not at 9 a.m., later on in the afternoon, at the Coinstar machine, at the Western Union counter. We also know from Ms. Pineda's testimony that this was also untrue. So given the evidence, and also the testimony of other two witnesses that placed him at the Luke Oil Mini Mart, I believe that Manuel Rosa was at the Luke Oil at approximately 9 a.m. that morning. He later on testified that he saw the defendant behind the victim at the cash register at 9 a.m. in the morning. Ovidio Rojas also testified that approximately 9 a.m. he saw the defendant standing behind the victim at the Luke Oil Mini Mart. So given all this evidence presented by the Commonwealth, we know that the defendant was not shopping on Newbury Street at 9 a.m.
See, but just what you're saying now, we know. I mean, that's what the jury is supposed to conclude.
I shouldn't say that.
But that is what is conveyed by he lied. It's I'm telling you, this is the only conclusion. He lied. Instead of saying, as jurors, you can see, marshaling this evidence, you can conclude that this was not a lie, that truthfully it was a lie. That's different.
Certainly, that phrase is different. But given the
beyond
fact that the trial prosecutor did say attacked the evidence and the defendant's statement by saying we know that it's a lie. Essentially, it's his duty on behalf of the Commonwealth to vigorously and strongly advocate on behalf of the Commonwealth, on behalf of the case, and which is what he did here, and it was entirely proper, and it did not give rise to any error at all. At no time did he characterize the defendant as a liar, an outright liar. He simply attacked the statements that they were untrue. They were lies, and there's no error in that respect. With regard to the prosecutor's statement that in every man's life, in every person's life, there comes a time to be held accountable, again, that does not give rise to any error at all, because the prosecutor properly urged the jury to consider their roles as fact finders, and to do so in this instance. And if there was any...
So it's a little bit of rhetorical excess there, isn't it?
Yes, and that's allowable in closing argument. A rhetorical flourish is certainly allowed, and it certainly could be characterized in that particular statement. But again, that statement in no way gave rise to prejudicial error, given the curative instructions that were immediately given after closing argument.
What about the, and I think it's actually repeated, references to the victim? I mean, in ways that, sister, niece, and if she wasn't there, she's in the pool of blood on the floor. I mean, you could call them rhetorical flourishes, but they're fairly, there are a number of them.
There's actually two of them, Your Honor. There's in the very start of the trial prosecutor's closing argument, he did describe the victim as a 39-year-old niece and daughter. Again, fair comment on the evidence because her uncle, Jose Cruz, did testify to that effect, and is simply an allowable manner to humanize the victim, who is truly, I mean, she's the focus of this case. And that was properly allowed. And that was done in the beginning of the closing argument. And as to references to the victim in her own pool of blood, that was in refute to defense counsel's closing argument that there was blood in the kitchen sink in the back office of the mini-mart. And why was there no DNA? Whose blood was it? It certainly was the defendant. And the trial prosecutor properly refuted that argument by saying, well, simply, of course it wasn't the victim's because she was lying in a pool of blood. And that comment was supported by the testimony by Patrina Sullivan, who was the first paramedic that arrived at the scene. Officer Dorsey also testified that she observed the victim lying in a large pool of blood, and as well as Lieutenant Murner, who testified that when he arrived at the scene, there was a large pool of blood surrounding the victim's head and neck area. So that is also fair comment of the evidence. And if there's any possible error, again, it was curbed by the instructions. The judge also gave an instruction cautioning the jury not to decide the case based on sympathy. So not only was there instructions that opening and closing statements were not evidence, but that the jury was not to decide this case based on sympathy. Unless the court has any, I could also address the use of brutal and vicious by the trial prosecutor. Again, that did not give rise to any error. The Commonwealth here pursued this case on a theory of extreme atrocity and cruelty. And based on the case of Commonwealth versus Byanowitz, the prosecutor is allowed a number of factors to show the jury that there were indeed, this crime was indeed committed with extreme atrocity and cruelty. And that dealt with the number of blows, the number of stab wounds. And here, Dr. Zane testified that the victim died of multiple stab wounds. She died from wounds throughout her entire body, in her neck, everywhere. And I think that's a fair comment that was a brutal stabbing. There was also testimony that when the victim was found, she had a bag tied around her neck. She had 2 cases of beverages stacked on top of her head. That was testimony throughout the trial, and again, fair comment on testimony, and also permissible given the fact that the Commonwealth pursued this case on a theory of extreme atrocity and cruelty.
One question which is not entirely related to some of the arguments. Was there evidence that the defendant knew the victim?
Yeah, I believe there is. I think there's inferences that can be made because Rodriguez, who was the manager of the store, gave a list of all the employees, past and present, to Lieutenant Murner. And on that list was obviously the victim and as well as the defendant. I know they work different shifts sometimes, but I think there's a fair inference that can be made, given that there was also testimony, I believe, from Mr. Rojas that he observed the defendant speaking to the victim while he was standing behind her at the cash register.
Coming through an employee entrance or something without response, at least no evidence of a response from her, even though he came in through this non-public entrance.
Exactly, yes. So I think that there's definitely fair inferences to be made based on the evidence that they're familiar with one another.
And what about the instruction?
The instructions were not unconstitutionally infirm in any way. The language pertaining to beyond a reasonable doubt were taken directly from the defendant's request for jury instructions. The use of moral certainty was the Webster charge, was linked to language that conveyed to the jury the high level certainty that was required to convict the defendant. And as to the other language, which is the Casali language, that was also proper as well, and that was the request of the Commonwealth. Here, Vanessa Pineda testified that when the defendant returned to the apartment after the atrocious crime, that he and a friend had robbed the store, that he and a friend had tied the victim up. So there's definitely an introduction that there's another person involved. The defense counsel's opening and closing argument also focused on the possibility that there was someone else, the failure to investigate the neighbors that lived directly next door to the gas station, that there are 3 people that lived in this certain apartment. So I think given the theory, the defense theory of the case, and Ms. Pineda's testimony, I think that this instruction was proper. And also, as to Justice Botsford's question earlier about whether there should be an additional sentence of instructing the jury that you should find this defendant guilty, I think that language was already included in the beyond a reasonable doubt, where the trial judge did say that this is the burden that you have to convict the defendant. So I think that read in its entirety, I think that there was absolutely no confusion caused by the trial judge.
Were the, I can't remember if were the instructions given to the jury? In other words, was there a printout?
I don't believe so. I did not get that from the transcript. I don't believe so.
So maybe just tapes, if anything? I mean, an audio tape?
I think a transcript then, yes. So not a tape, but a transcript was provided to the jury. In closing, the Commonwealth also asserts that any request for relief under Chapter 278, Section 33E should be denied. As I've stated throughout my entire argument, this was an absolutely atrocious crime. Lourdes Hernandez died in a horrific way, and there was overwhelming evidence supporting the defendant's conviction of first-degree murder, and any relief should be denied. Thank you.